Friends, at a particular age of one's life, everyone searches answer to one very important question, and that is it better to distribute the assets during one's lifetime or after a demise? Which succession tool is best suited to a person's needs? It is because more than 75% of the court cases in our country are about family and property disputes, and also about 65% are only property disputes. Many of these family and property disputes, friends, can be attributed to absence of a will or a testamentary ambiguity, as we call it. So every well-intentioned or a knowledgeable person would definitely like that he should ensure that after his demise, his property owned by him or assets created by him in lifetime are shared among his successors as he may wish, and there doesn't arise any disputes among his successors, etc. etc. Before answering this important question, one has to know about the succession laws prevailing in our country. A person, when dies without writing any document, that is a will, is called having died intestate. So if one dies intestate, all his property or assets, liquid or immovable, everything will be dealt with as per the succession law applicable to the religion of the deceased person. For example, Hindus, Buddhists and Jains are governed by Hindu Succession Act 1956. And for Christians and Parsis, it is Indian Succession Act 1925. Muslims are dealt according to Muslim Personal Law Shariat Application Act 1937. We will discuss in some other video about Hindu Succession Act in detail because it is an elaborate act which deals about settlement of a person's asset dying intestate, that is without writing any will or leaving any testamentary document. So let's first talk about will. Will or a wasiyat is a document written and registered by the testator. Testator is a person who writes a will during his lifetime, read and implemented after the death of the person or the testator. The beneficiaries need to get the will probated in the court to get it executed. Here the testator has exercised his power and chosen his inheritors as per his their will and wish. Because it is read after the demise of the person or the author, a word of caution here is that will must be drafted very, very carefully and got witnessed by two persons and got registered in the office of sub-registrar. Its contents must be unambiguous. Though a will is universally acclaimed for its efficacy, it can still be contested and can trigger family conflicts after one passes away because it is read afterwards. Is it then better to distribute your assets while one is still alive, or should one resort to instruments other than will? So what are other tools available? Number one is gift. Gifting assets can help avoid acrimony among family members, and assets are passed on to the intended beneficiaries during the person's lifetime. Besides this, it is easy to execute and helps avoid probate for the legal heirs also. The gift allows immediate and dispute-free transfer of ownership. Further, gift to your relatives, blood relatives, are tax exempted, making them very efficient tool for early, very quick succession. However, gifts to non-relatives is taxable in the recipient's hands. A Hindu has also an option to gift personal property to the family HUF or his own HUF, while this is not taxed in the hands of the HUF. Very important. Next tool is selling one's assets and converting them into cash or financial legacy. It also seems like a simple exercise resulting in fair distribution in one's lifetime and also keeping family friction at bay. This is better in case your children are living abroad, having demanding careers and are not interested in maintaining your properties even today or even later. But friends, selling assets can attract capital gain tax and also stamp duty in case of real estate and may also be affected by the prevailing market conditions. So not very simple. But this is a good tool. One of the most effective and robust tool is also creating a private family trust which can be formed during one's lifetime with oneself and his or her heirs as the beneficiaries. It allows the creator to specify specifically how assets are to be managed and distributed and maintained, particularly maintaining confidentiality and avoiding its probate. And then settlement deed is also one of the legal documents that gets all family members to agree to particular terms of distribution of assets. Then friends, one very important tool to which government is also largely advocating is nomination. This is a very simple way to transfer movable assets, particularly bank deposits, equity investments, shares, life insurance, mutual funds, retirement accounts, bank lockers, etc. You can nominate anybody. It requires only documentary proof of the deceased and the nominee to claim the deposits and the investments. A simple exercise. Here remember that a nomination does not confer direct ownership to the nominee, as the nominee is only a custodian of the assets of the deceased. Very important to note that. But if nominee is also a legal hire, it can be the best method for transferring of one's movable assets. As I have mentioned above very clearly, what are movable assets? Joint ownership accounts with a survivorship clause, that is having bank accounts with survivorship clause, that is either a survival. It is very important and very simple to access to the funds and investments. The joint holder along with the deceased gets the quickest transfer of funds after the demise of the joint holder. Finally friends, while it is advised that use your assets in your lifetime, enjoy them, but if having decided otherwise, then it is advisable and better to ensure distribution of one's assets through a will so that it is implemented after one's death only. Hence, I recommend that writing an unambiguous will is the best option. Thank you, friends. Long live and enjoy your assets very nicely, happily. Hope this content of the video will be useful for many senior citizens. Bye bye, friends. Have nice times. God bless all of us.